On this week's podcast of Bald, Blind, and Buddies, Timmy and I have the distinct honor of talking to an expert on police behavior, qualified immunity, and other things. She's written a book called Shielded. We welcome Professor Joanna Schwartz of UCLA Law School. Bald,
Blind,
and Buddies. Well, Timmy, TGIF to you, Timmy C. How are you, good doctor?
I'm good. I noticed, John, it's warmer here than in Los Angeles. Did you know that?
That is not something I was familiar with. Why is that happening? And please tell me it's because of global warming, which I know you advocate for.
Oh, no. Well, it's because the middle of the continent has more swings in temperature, right?
I don't know. You're
I
the
think
scientist.
so. Yeah, no. Yeah. You look at like the steppe in Russia, and it's worse. So.
Well, Timmy, we are blessed and honored, actually, because our conversation around qualified immunity, you know, Timmy, I taught on an adjunct basis, taught constitutional law. I'm fascinated by it. I also like to preface this by saying two things can be true at the same time. I understand police behavior and the history of racism associated with the police. That, however, does not mean we need to do away with the police. And so when we talked about qualified immunity, I took it as an opportunity to reach out to one of the foremost experts on that subject, and we are joined by her today. This is Professor Joanna Schwartz of UCLA, University of California, Los Angeles Law School, a distinguished professor, and further, one of the leading experts that you see on television talking about qualified immunity. And as I joke, Timmy, you know I'm a classic liberal, small L, but I also tend to be a capitalist. And so she has recently written a book. And so we're going to give Professor Schwartz free rein. Go ahead, plug your book. Tell the dozens and dozens of people that listen to our podcast every week about your book. And you can tell, Professor Schwartz, we don't take ourselves too seriously. So welcome. Happy Friday to you, miss. And it's a pleasure to have you on our show today.
Oh, yeah. Thank you. Thanks very much for having me.
You know, I'm a psychiatrist. I come at things differently by nature. You know, I read your book and about all the ways that the police are shielded. And I was curious. I asked myself, why isn't it worse? Like if there's all these protections and the police can get away with so many things, why aren't we having roaming bands of police? And what are the factors that are keeping things as good as they are? You know, in a light to how things could be better. I'm just curious from that angle.
That's a really interesting question. I don't think that I have ever been asked that question, and I think it's a good question.
Welcome to being friends with Timmy C.
I love it. I love it.
Schwartz.
I think it's a really good question to ask, and in fact, I've been thinking about it, or a related question, in recent days, because I think that what you see ICE officers doing right now, into my view, is more in the category of roving bands of people who are using extreme force, and force that it seems intolerable to my eyes. Certainly
mine as well, Professor, so you have a good company here. Yeah.
It certainly seems like the kind of videos that would have 5 years ago caused even more outrage than causing now. And so I have been thinking about this, and I do believe that there are many legal shields that prevent police officers, state and local police officers, from being subject to justice through the courts. And some of them are related specifically to the kinds of legal doctrines that I talk about in the book, including qualified immunity, but not at all limited to qualified immunity.
Hey, Professor Schwartz, I'm sorry to interrupt. Why don't you tell the listeners the name of your book and what its premise is? Because I'm familiar with Shielded. Yeah.
Great point.
The 7 or 8 people listening are not.
So the book is called Shielded: How the Police Became Untouchable, and it's something I published in 2023. And it's a book that really focuses on all of the various challenges that make it difficult to sue and difficult to win and difficult for lawsuits to have the effect that you would hope that they would have, including providing some sort of justice for people who have been wronged and some sort of accountability against the wrongdoers. And as I explained in the book, there are all of these different legal shields, barriers that make it difficult to get justice in these cases. And that matters, I argue, in part because there's not other avenues to get justice often in these cases. Internal affairs investigations are even more limited in what they can accomplish. Criminal prosecutions are sometimes available, but really very rarely and even more rarely successful. So often it is that people are looking to find justice through the civil courts, through damages actions, seeking money or seeking some sort of forward-looking relief. And despite all of the barriers that I talk about and believe that are there and believe are unjustified, there are still people bringing these cases and winning. And there are examples throughout the book of people who do win, maybe not as often as they should, not as much as they should. Sometimes it's not the victories that you would hope it is, but people are managing to get some justice out of the system, and winning in those cases can be very powerful to the individuals who were violated, can unearth really valuable, important information, create orders that departments change their behavior, and various other things. This gets me, though, to the question about ICE. Federal agents essentially can't be sued under the protections or under the causes of action that state and local officers can be sued. There's even more barriers and limitations for federal officers. And so when you ask why, given all these protections, aren't there roving bands of police doing unmentionable things, I think in part it is because as limited as this system is, it does still exist. It does still exist, and it does work in some instances. And maybe what it does is show why these cases remain important to bring. And when you compare what ICE has been doing, there really is not recourse in the courts for against ICE officers, and maybe that's the difference.
Professor Schwartz, you paid Timmy and me the highest of compliments because you had talked about listening to our qualified immunity. We are not going to purport to be experts on qualified immunity. I would say you are. To that end, I'm going to ask a two-part question, if that's okay. Could you, well, not a question, I'm going to make a statement. Could you tell us a little bit about the history of qualified immunity? Because it doesn't just apply to police officers, it applies to elected officials. And I think the premise behind it is sound. And as I argued in the previous podcast, I think it needs a little trimming around the edges. But secondarily, why do you suppose the Supreme Court's jurisprudence basically essentially says, unless the fact pattern, meaning this exact thing happened, that you can't sue? Why do you suppose that is? Is that just sort of a historical anomaly? Could you tell us a little bit about a qualified immunity writ large, and what do you think of the Supreme Court's jurisprudence in that area?
Sure. So starting at the beginning, qualified immunity is not written into the Constitution. It's not written into Section 1983, which is the short named for the statute that people use to sue state and local officials for constitutional violations. It was created by the court in 1967, which was 6 years after the court recognized that there was a right to sue for violations of the Constitution. And what they talked about in that case in 1967 was essentially the desire to protect a police officer in that case from civil liability in very close cases. There was a statement in that court decision which I have always liked, which was that a police officer should not have to choose between being mulcted in damages, covered in damages if he acts, and brought up on discipline for failure to do his job if he doesn't act, that there should be some space, some legal protection for operating in those gray areas when officers are acting in good faith. So I agree with you that as an idea makes sense to me. As a side note, I think it's now sort of written into constitutional protections, like the Fourth Amendment, which protects against unreasonable searches and seizures, is sort of the constitutional protection that protects against unlawful force and wrongful searches and wrongful arrests. And already in those protections, there's a recognition that officers sometimes can make mistakes, and so shouldn't be held liable if they make essentially a good faith or reasonable mistake. But anyway, that's a digression. That is what qualified immunity was intended to accomplish. But then just 15 years later, in 1982, the Supreme Court wholly recreated qualified immunity. They got rid of the subjective element, so it was no longer focused on officers' good faith. It was focused on whether officers had violated clearly established law, and meaning law that had previously been enacted. So is this conduct clearly violative of conduct that a prior court had ruled was unlawful? The reason they made that shift was to make it easier to grant officers qualified immunity, and specifically to protect them against what the court called the burdens and distractions of being a defendant, of having to sit for a deposition, of having to go to trial. If the case is about whether an officer had good or bad intent, then you really have to get inside the officer's state of mind, which would require a deposition or other kinds of testimony. And if it's an objective standard, then the idea is that you should be able to resolve it without having to depose the officer. So that was the reason for the shift from officers' good faith to whether the facts are similar to a prior court case. And over the years, since 1982, the standard has gotten more and more difficult to meet, such that in cases, in recent years, the Supreme Court has said that the prior case has to be factually similar enough to the case at hand that every reasonable officer would know that the conduct was inappropriate, which is a very difficult standard to meet. There's a lot of reasons why it is very difficult to find a case like that, and I'm happy to talk about all of those ways. But I don't think, you asked whether that standard makes sense. It does not make sense to me. And if what you are trying to do is punish bad actors or people who are acting in bad faith, whether their conduct is sufficiently similar to a prior court decision, it's not the best way to get to that information, and it may not be a way to get there at all.
Right. Yeah. You have to rely on somebody doing the exact very similar wrong thing previously and getting caught, right? For this to, yeah.
Well, and even going beyond that, someone prior did something similar, someone filed a lawsuit about it, then the case resulted in a written opinion. Right. To make this point with an example that everyone knows, when George Floyd, the lawsuit filed by George Floyd's family was settled quickly without any court decisions. So there is nothing about George Floyd's murder that clearly established the law moving forward for qualified immunity purposes. Nothing about his lawsuit, his family's lawsuit. So if you're just tied to situations where courts issue opinions, you're not only limited to just prior similar cases that made it to the courthouse, it's also you're limited to prior cases that made it to the courthouse that also made it to a court decision deciding the merits of the case.
Right. Wow. that is a high bar.
It is a very high bar.
Professor, one of my favorite lines is by Michelle Obama, and she always said that power doesn't change who you are, it reveals who you always have been. And what I'm asking is, 30 years ago, there's a local radio host here in Philadelphia by the name of Michael Smirkana. She's now national and such. And he started out as a criminal defense attorney and such. And he said that, when a police officer would testify, he knew he would won the case because there was sort of a deference, an almost sort of idol worship, if you will, associated with police officers, that whatever they're saying has to be the truth. Do you think that the existence of body cams, videos is changing the dynamic? What is changing sort of the pendulum as you see it? Because 1982 is when this started, and it's gotten even more stringent, as you said, over the past 40 plus years in terms of qualified immunity and shielding police officers. What do you think will ultimately change, or is it changing as you see it, the public's perception of qualified immunity, of police behavior, of, as you say, shielded, bad cops that are protected? What do you think will ultimately do that? Do you think it's changing? Give me hope is what I'm saying.
So I do think there is more, less hero worship.
You agree with that premise, though, right? If a police officer had said something to me in the 1990s, I married, not to pick on poor Timmy, but I used to believe that if a doctor told you it was factual. Now I've come to find out that if you get 10 doctors in a room, you're going to get 11 opinions. And, not to minimize it, but you do agree with that premise, though, because I just want to make sure that I'm not coming out of left field with that if a cop said it, I bought it. Juries buy it.
Yeah, I think that that's true. And there is some evidence to back that up as well. Pew has done surveys of how the public thinks about various professions, and police have been within the top 3 most trusted professions for many years. And I haven't been looking in the most recent years, but after 2020, police were replaced. They only went down to number 4, but they were replaced by medical professionals. Yes. And of course, none of that is coincidental. 2020 was.
We don't have to talk about 2020 on this podcast. It's a bad year. Yeah, I think we all can concede that. Yeah. I was okay with the election results, but yeah, I was okay with the election results.
I was thinking of George Floyd plus COVID,
Oh yeah, that's what exactly.
The view of medical professionals to go up and police to go down. And I do think that video, and people have talked a lot about how body camera video, surveillance footage, people's phones, recorded camera footage have really changed people's perspectives and shed a light for people who have never had a negative interaction with the police, that such things are possible and maybe even common. So I think there is, and I have to say, in this current moment, there's so much video that's showing up often of federal officers these days, but I would imagine that will continue to color people's perspectives. And in fact, one data point about that is that in Washington, D.C. And elsewhere, juries are refusing to indict people where there's charges against people for assault against law enforcement or assault against ICE officers. Those indictments, juries are refusing to indict, which is unusual, but I think reflects something about changing perspectives about what law enforcement is doing. So I do think that there is more skepticism now, or less ready willingness to simply blindly accept what it is that's being offered by law enforcement. As far as qualified immunity goes, I also think that there's some increasing skepticism about qualified immunity, and it has been attacked by people on the left and on the right from a variety of perspectives. There is this sort of police accountability or government accountability arguments that carry weight with some people, but not all. There are originalist arguments, essentially, that make the point that qualified immunity was basically a creation of the Supreme Court, and we, should not be relying on that kind of judicial activism. And then there's a set of arguments, and these are the ones that I have really focused on in my research, that qualified immunity doesn't actually achieve the policy goals that it's intended to achieve. Officers,
really? Can you extrapolate on that?
Yeah, absolutely.
Yeah, I'm sorry.
So one common explanation for qualified immunity is that it is necessary to protect officers from the financial burdens of being sued, from being mulcted in damages, as that 1967 case said. I studied police misconduct payouts in 81 jurisdictions across the country over a 6-year period, and I found that 99.98% of those dollars were paid by local governments or insurers, not officers. And the reason is because states and local governments have indemnification agreements or statutes that provide that when an officer is sued, they will be provided a lawyer, and a settlement or judgment entered against them, so long as they're acting, within the course of their employment, will be paid for by the jurisdiction. So that is a protection that exists wholly apart from qualified immunity, and is a protection for officers' bank accounts, and would continue to be one even if qualified immunity didn't exist. So that's one example. Another example is that qualified immunity is justified by this idea that officers need to be on notice of the wrongfulness of their conduct before they are sued for that conduct. And that you need to have these prior very similar factually analogous cases. So I simply looked at hundreds of California training manuals and police policy manuals to see how they are trained about use of force. And what I found, which again wouldn't be surprising to people who practice in this area, but sometimes you have to actually gather this information, officers are not trained about the facts and holdings of the hundreds of cases that define whether force is clearly established or not. So the kinds of cases that a plaintiff and their lawyer need to find to overcome qualified immunity are not cases that officers are actually reading or learning about. Instead, they learn the general framework for excessive force under the Fourth Amendment, and then they're taught to apply that standard in a variety of situations. And that is not done in relation to court decisions. So this whole idea of notice is also really imagined.
So, Professor, we had talked about the most recent Supreme Court case, which basically took into question the totality of the circumstances as opposed to the imminent threat doctrine and so forth. Essentially, this motorist was shot because he pulled away. And based on the overall reading of the case, it seems like that's a case that police officers should be taught. What you're saying, and correct me if I'm wrong, is, everyone who has a television or has watched Law and Order knows what the Miranda rights are. I can, recite them right now, so to speak. It's almost part of our everyday vernacular. What you're saying is police officers are just not familiar with these excessive force rules. Is that a fair statement of what you're saying?
Not quite. Let me amend or clarify to one degree. So when there are what I would call watershed cases that articulate a new legal standard, I do think that officers are trained about those watershed cases. And it's one reason why I think litigation is really important, because when you do create, for example, that decision is going to have an effect on training moving forward. The notion that in the Fifth Circuit and in other circuits that had followed a similar rule, you cannot look just at the moment before force was used to assess whether it's reasonable. You have to look at the totality of the circumstances to figure out whether force was reasonable. That is a new standard that I think will absolutely have an impact. But what the Supreme Court's qualified immunity decisions have set up is a world in which the expectation is, if you take the court seriously, that officers aren't just on notice of those watershed cases, but on the facts and holdings of all the applications of those watershed cases.
Oh, I see what you're saying. Okay.
So, as one example that I talk about in the book, there is a case called Baxter versus Bracey, which was a case where a man had burgled a home. The police came. He sat down on the ground and put his hands in the air. He surrendered, and then the officer released a police dog on Mr. Baxter and injured him. He brought a case, and he argued that excessive force was used against him. And it is well established everywhere. I think officers would be trained anywhere on the notion that you cannot use force against a person who has surrendered and is not posing a threat. That's a generalized principle. In this case, actually, Alexander Baxter had something more. He had a prior case that said that in that very circuit, in that very court system, it was excessive force to release a police dog on a person who had surrendered. So it was even more, more specific. But to the Sixth Circuit's view, that prior case did not clearly establish the law because there were sufficient factual differences between the two cases. In Alexander Baxter's case, he was sitting on the ground with his hands in the air when the police dog was released. In the prior case, the person was lying on the ground when the police dog was released. And it's that kind of factual distinction that can be the basis to grant qualified immunity. So that's very different than the notion that all officers are going to be trained that you can't use force against someone who is surrendered.
I don't think police officers are trained on laying down versus sitting for a surrender.
Exactly. And they're not trained on that, and they certainly aren't trained on the facts and holdings of prior cases. If you can imagine reading hundreds of cases about use of force, the idea that an officer in the 20 hours of training that they might have every year or every few years, that the bulk of that time spent reading and memorizing the facts and holdings of cases is sort of inconceivable. It's not how anyone would think that they should spend their time. And then the idea that an officer, as they're deciding whether to release their police dog, would sort of flip through their memory bank and think, is this like the case where someone was lying down? I don't know. It's not plausible. But that is what the court's decisions suggest is happening.
Yeah, it's interesting. It's as if in the moment they should have a set of general guidelines. Like I'm going to use a music analogy. So, I'm improvising in the key of G. I know what notes will usually fit, and I don't have to know every particular note at any given time point in a song, and I can play along, right? And so they're improvising as they do the police thing, and they can't memorize every score, right?
And no one would ever, anyone who thinks about error science, who would think about, creating a system for safe aviation or, a nuclear generator, everyone who thinks about how to manage complex situations and uncertainty, think about things like checklists, like the checklist manifesto, or what anyone or in medicine for sure, what anyone thinks about reducing risk, you think about creating a short rule of thumb and then getting comfortable applying it, which is in fact what police trainings do. They don't learn about each individual case; they learn about the general principle.
Right. It's interesting you mentioned the indemnification. We had Bob Ricks on, who was a special agent in charge at Oklahoma City after the bombing, and he told us
$1 billion, Timmy.
$2 billion. So for 20 years, he said he had suits pending for $2 billion. And he said it hangs on you, I think is what his quote was.
Yeah.
And it's interesting, should he not have been worried? Or, I from everything I know, he, I think, did a pretty good job. And
well, $2 billion, I mean, I don't know exactly what the circumstances.
He said in claims, and I think it related to Waco. So
against him personally?
Yeah. So
yeah, that would.
If you'll indulge me for a second, Professor. So I just have to tell a quick story about Bob Ricks. This is actually, I'm kind of stealing the thunder for what I was going to do at the end anyway. During COVID, there was a joke that you became a monk, a hunk, a drunk, or a chunk. And people, whenever I tell people, I always get the same response. They always giggle, and to a man, everyone will say, only just one? But I actually found myself to be productive. I had gotten myself a smoker, and I started making some stuff. I have a small nut and jerky and treat business, which I did tell you about in my multiple emails to you. But as a thank you, you get to pick.
Right.
And anything you want. But the reason I'm bringing that up is Bob Ricks, who is now 81 years old, had said, I really like spicy, so I make these honey smoked spicy peanuts. I sent them to him, and I thought, he's 81 years old. I probably shouldn't profile, but I hope he's okay. I hope I didn't give him heartburn. I sent him a text, and I said, did those nuts go down okay? And you know how he responded? I grew up on the Mexican border. I'm good. So it's proof that there are differences in spice appreciation. But to that end, and we are capitalists here, I think it's a fabulous, powerful tool for the alleviation of poverty. However, I don't believe in absolute capitalism as my counterpart Timmy might. To that end, why don't you tell us a little bit about your book, Professor? Tell us what motivated this, Shielded. What were some of the significant findings, and how has it been received? Because I want to tell our listeners about what they should be buying.
Well, I hope, the reason I wrote Shielded, I started in 2020, and it was sort of around the time again of the summer after George Floyd was killed, and there was so much focus and attention on things like qualified immunity. And I was trying to do what I could to educate people about qualified immunity and through the press, and I decided to write Shielded to try to explain some of these complex legal concepts and to explain them in ways that people who are not law professors, who don't like to read law review articles with hundreds of footnotes, would still find interesting and understand. So that was a main driver. So I do think if you're someone who's interested in what qualified immunity is, or some of the other protections that I talk about, I hope, and Timothy can weigh in on whether it's true, that it's something that a non-lawyer should be able to take in and understand. Another part of the goal and interest was to make sure that the conversation wasn't just about qualified immunity, because that is an important protection and one that does deserve criticism and reform. But there are a lot of other barriers to bringing these cases. There's a lot of parts of the country where there are not enough lawyers to bring these cases. There are challenges in bringing claims against local governments, who are often the ones that are really responsible for what's happened in these cases. And then because of things like indemnification, there are limited ways in which these suits actually affect the officers who've been found to engage in wrongdoing. So part of my goal was to try to, in addition to talking about these legal barriers in a way that everyone could understand, to talk about all of the barriers and the way they fit together. And the last thing I would say is my goal was in the book to explain these things through stories of people who most readers will have never heard of, through cases that you wouldn't have seen in the news, but whose stories are nevertheless really important to them, and also show how these barriers really affect people and the cases that they're bringing. So
Well,
Those
you did
are
just that with the Baxter case, Professor. So,
what's that?
well, I say you did that with the Baxter case you told me about. I was not familiar with that.
Yeah.
And here for that. So exactly, it seems to me that I will be buying that book tonight. So
Good. Good.
Yeah, I found it really, really helpful. Just the little things like the standards required for a pleading to actually start discovery. And it's hard to get your foot in the door, and there's questions on compensation, and I learned a heck of a lot. I guess I was curious when I think about consequences for individual action. Do you think like the police unions, like there's a role in protects officers from like I work at an at-will employment where if my employer doesn't like me, I'm out of there.
Yeah.
Do you think that has played a role in slowing certain reforms?
affectionately referred to as the blue wall of silence, right?
Absolutely. So union agreements, memorandum of understanding that unions and local governments entered into, often have provisions that make it more difficult to have consequences against officers who've engaged in wrongdoing, and those can range from limits on how long a internal affairs investigation can take, or requirements that an officer be able to watch body camera video before being questioned about their involvement in an incident. It can involve provisions that require the department to throw out all internal affairs investigations, even substantiated ones, after 3 years or 5 years. And so all of those kinds of limitations can make it difficult to get disciplinary action against unions, and also to prove cases, to prove lawsuits, because some of that information would have been relevant to proving a case against a local government, for example. So unions are a big part of the story as to how these various barriers to relief have come into play. And they've also played a role in, for example, opposing efforts to reform qualified immunity. So the unions have been advocating for a lack of accountability through internal affairs investigations and also through the courts. They've played a big role.
I just have one last question for you, Professor. But before I do, if you'll indulge me in a little bit of a soliloquy. My wife's grandfather was the chief of police of Scranton. One of my best friends is a police officer. I have nothing but admiration for good cops. It's like anything. So, I want to put that out there for the listeners and such, but I do have to ask you something. So, Sister Helen Prejean was, the famous death row against the advocate for, eliminating the death penalty and such. They made a movie about her back 30 years ago called Dead Man Walking.
Sure.
And in that movie, she gets pulled over by a police officer. And he says, "You're a nun?" And she says, "Yes." And he says, "Last year I pulled over an IRS agent. I got audited this year." He says, "I don't want to find out what happens if I, give a ticket to a nun." I'm curious, have you had any blowback from the police for your research, your scholarship and such?
I have not. I mean, I've certainly, there have been times where I have been on panels with, it's usually not police directly, but maybe union attorneys who may disagree with me about something like qualified immunity. But I have not gotten blowback in that way. In fact, the most criticisms that I have gotten is that I haven't gone far enough. I don't end the book calling for abolition. So to the extent that I've gotten pushback, it's been in that direction. And I wanted to say,
the good cops want the bad cops out too, right?
I think that is right.
Yeah.
I also I thought long and hard about how to frame this book, and how to think about that kind of question. And one thing I say in the introduction is one sentence I have in the introduction is this: whatever one believes about the job of policing, whether it's that well-intentioned officers often must make split-second decisions that are easy to criticize in hindsight, or that the profession is corrupt by its very nature, Videos that have filled our screens in recent years offer concrete evidence that the police sometimes egregiously abuse their authority. And the book is about what the consequences should be when they do. So I really try to be very clear from the beginning and throughout that this book is not a condemnation of the police. But if we can be on the same page about the fact that police do sometimes abuse their authority and that there should be consequences when they do, this book is focused on what those consequences should be and why I believe they're not as strong as they should be.
I have a kind of semi-related question. So I always think from a medical personal angle. When I was at the VA, it seemed like they were very interested in how to treat post-traumatic stress disorder, but not necessarily figuring out who was at risk of getting PTSD, because I think maybe that would cut down on the number of soldiers you could put in a field. Right. And I wonder with these police officers, some of the stories you read are just, to me, sitting in my comfortable living room seems so egregious. Like there's, a psychopathology or other things at play. Do you think, there's individuals that could be screened? Because the after the fact kind of reminds me of, cutting out lung cancer when you should have had people stop smoking. Yeah. Like, are there ways other than training, personality or culture, ways to identify these problems so that it doesn't get to this whole legal position?
Yes, absolutely. And, if you are looking for a future guest in this general area, a person who would be really interesting to talk to about this is named Philip Atiba Goff, Goff. He's at Yale. He used to be at UCLA. He's a psychologist. And he has done a lot of research about the psychological makeup of police and done a bunch of testing where he has done various psychological screening and has come to conclusions about how those variations sort of match up against proclivities to use force. And I've seen him give presentations that are absolutely fascinating. He's probably moved on to other areas, but the paper that I remember hearing him present was about masculinity threat. And the research that he was finding was that if someone tested in a highly reactive to masculinity threat, that they were far more likely to use force quickly. And that was more of a predictor than people's views about race, even than people's gender. It was a really key determinant for them. So that's just one example, but I think that there is all sorts of psychological testing that is being explored to assess those kinds of proclivities.
Yeah, and you describe in the book certain types of searches which look very emasculating, yes. Whereby the officer may be responding to that threat with that action,
Yes.
And that's all armchair hypothesizing. So,
yes, yeah, absolutely.
Well, Professor, one of the traditions we have every week, please take it for exactly as silly as it sounds. We offer our listeners an opportunity to present their respective hero or whack job of the week. As I note, based on my politics, I am, presented with ample opportunities to call out some of Republicans, if you will. You don't have to choose a whack job. You don't have to choose a hero, but we always like to extend that to you. Did you have someone in mind or some group in mind that you'd like to honor or, kind of poke fun at this week?
Well, I do. I am very distraught by things that are going on in the world right now, in our country right now, and I think my heroes for the week are some of the judges who have been issuing opinions in recent days that, to my view, are protecting and standing up for the protections of the Constitution. And the hero, if I had to select one for this week, would be U.S. District Judge Bill Young. who issued a very lengthy decision out of Massachusetts about U.S. government violating First Amendment rights by targeting pro-Palestinian student activists for deportation. And the opinion itself is beautifully written, powerfully written. I think it will be one that people read for years to come. And so my hero for the week is Judge Young.
Do you want to hear how big of a whack job I am, Professor?
Sure.
I'm familiar both with that judge and with the ruling. I haven't had a chance to read the opinion, but I knew what you were talking about. That's how big of a geek I am. So.
Well, watch what you say, because if that makes you a big geek, then what kind of geek am I?
Yeah, but you do this for a living. I do this as a hobby. There's a difference. You get a paycheck, So.
Fair enough.
Well, Professor, I have to tell you, it was a tremendous honor. I hope you will consider coming back on if an invite is extended, and we'll talk offline. I'll send you an email. But check out WC Nuts, westchesternuts.com.
Okay.
As a funny aside, people say it sounds dirty, and I kind of hope I do, because it's estimated that half of the traffic on the internet at any given moment involves pornography, as sad as that is. So, yeah.
I always think of Hillary Clinton whenever you say nuts in Westchester. Like that's where I go, but that's me.
That's fair. That's fair, Timmy. That's fair. But listen, it was, all kidding aside, it was a tremendous honor. I think our listeners are going to benefit tremendously from this, and I hope you see a spike in your sales as a direct consequence, and that Timmy and I can take credit for that. So,
well, what I hope is that people who are interested will take a look, and I get about 2 cents for each book that gets sold. So it's not really about the money, but it is about sharing the information. So
well, our listeners could get you a coffee. So
exactly.
Well, listen, Professor, have a wonderful weekend. Thank you so much for joining the Boland and Buddies podcast.
Really
it's been a pleasure. It really has.
Of course, the pleasure's all mine.
Timmy, it was exactly what I thought. She was brilliant. She knew her stuff. She told great stories. I am going to get the book. When she told that story about Baxter, that's when I realized this woman knows what she's talking about. These are extraordinarily important cases that no one's ever heard of. Everybody knows Miranda, right? Yeah. Everyone knows that.
I learned Brady. I learned Brady and Iqbal and Minnell decision. I learned a lot from the book. So.
Right, but I think her point is well received, which is it's for non-lawyers. I
enjoyed it. I learned. Yeah. I can read dry stuff, but it was good. I liked it.
Yeah. And I found her to be a compelling listen as well. I thought her knowledge is unquestioned. Her ability to dissect ideas was, obviously very well appreciated. But I also found that sentence she read from the book directly, I thought was brilliant. You know, whether or not you think that the police are the bane of the existence, or whether or not you see them as, idols. Two things can be true at the same time. Let's agree on bad cops.
I don't know. Maybe once she mentioned police unions in the book as part of it. So I thought I would bring that out. So,
geez, tell us why, Tim. It couldn't be your conservative leaning principles, could it?
No, I don't think so.
Hey, Timmy, listen, as always, pal, you have a wonderful weekend. And this is John Boland saying, stay out of trouble, stay away from the police. And then this isn't an issue. But all kidding aside, this is John Boland saying, hey, misbehave, drive fast, take chances.
And this is Tim saying, when you meet the police, let them know they're in charge. And then, if everybody likes what you're doing, you're probably not doing anything worthwhile. Take care out there. Let's keep talking.